We are very happy to welcome Professor Peter Goodrich, who is a director of the Program of Law and Humanities, Cardozo School of Law, New York. The theme of today's lecture is Jurisliterature, an analysis of the role of literary figures in legal decisions. Professor Goodrich is the director of the program in Law and Humanities, Cardozo School of Law, New York, and a visiting professor, School of Social Sciences, New York University, Abu Dhabi. And he was the founding dean of the Department of Law, Birkbeck College, University of London, where he was also the Corporation of London Professor of Law. He has written many scholarly texts and articles on the subject, on his area of expertise. He has co-written an award-winning documentary, Till We Meet Again. There's a very interesting information about Professor Goodrich. He's a published chef who also specializes in inventive culinary and comestible uses of rhubarb. And he has even shared a link for his recipes. So maybe someday I'll share it with all of you. Thank you, Professor Goodrich, for accepting our invitation. We may start with the session now. Thank you.
Many thanks to Binny and to the Nirma Institute of Law. A great honor and pleasure to be here. And so my title is Jurisliterature, that's my theme. Let me then commence a panjandrum, a proliferation, periphrasis, prognosis, panoply, and persiflage of welcomes to you. And I'll go immediately to the question in hand. My theme is taken from a sentence from Vico's New Science. Giambattista Vico, author of the New Science, an important work in jurisprudence, states at a particular point that men of limited ideas take the law for what the words expressly say. Men of limited ideas take the law for what the words expressly say. Underlying that is the thesis of jurisliterature and the theme of the rhetoric of law, but also of all analyses of language and law. Words carry a social history. They bear the bodies and the affects, the atmosphere and the stories that their previous use, their previous speakers, the previous dialogues and discourses in which they were imbricated, carry in them and exist internally, so that in language, there is always more than is apparent. There is a resource and a depth that literalism or lack of ideas leads lawyers frequently in positivistic fashion to miss. But there in the story, in the narrative, in the depth of language, we have an opportunity. Jurisliterature is, and I will start with an oratorical definition, a negative definition. It's not belles lettres. It's not what literary criticism, it's not what novelists, it's not what Jane Austen or Dickens says about law. It's not about the prettification of legal discourse, not a question of ornament or of addition to the process and the expression of judicial and legislative decisions. Jurisliterature is a term that I take from a French scholar, Tessier Ensminger, and a work called Fabuleuse Juridicité, a historical study of literature as the foundation of law. Jurisliterature, in other words, is the genre of lawyers writing about law, literature internal to law, the figures and rhetoric of law, of course. But Jurisliterature starts with all of the imaginative endeavors, with all of the foundational works that look at Ides Legum, that look at the Tower of Justice, that look at all of these architectural metaphors, and those are just titles of some early introductions to law. All of the ways in which law interfaces with the general public, all of those ways in which lawyers introduce law, make legality accessible to the general public, to the other disciplines, the circulus disciplinarum, but also to a broader public sphere within which law, of course, does its work as one of the bonae artes, one of the good or the beautiful arts. Fabuleuse juridicité means, how do lawyers invent law? How is it fabricated? Upon what is it founded? All of the introductions, all of the enchiridia, all of the prolegomena, all of the preparatives, directives, and other preparatory works to law are an extraordinary resource, a jurisliterary scheme and theme that allows law its place and lures a civility, a sociality, a community, a sociolinguistic register other than that of law into the discourse parameters and the instruction of life that law provides. So what's the first theme? The first theme would be that literature, and most specifically jurisliterature, is foundational of law. Where does law begin? Upon what is law founded, structured, predicated, based? And it is based on all of those institutional writings, all of those foundational works that introduce the student, the first member of the public, to enter law. Juventus cupida legum, as Justinian says at the beginning of the foundational or first institutes of the Western legal tradition that the Renaissance rediscovered, along with Gaius. But what does he say? That this is what you need to know if you are eager, if you are lusting for law. In other words, this is a literature that is peculiar because it is an institutional literature, because it will instruct life, because it is luring you into the framework, the mindset, and the institution of legality. So jurisliterature is the study of the way in which lawyers use literature to found, to adumbrate, to structure, and to express law. So jurisliterature is mos literatus juris docendi, and I apologize for the Latin, that's a professional defect, but it is the literary mode of teaching law. And if you look at the Western tradition, and I will divagate here just slightly, then you will see that each of the national traditions of law that inherit the corpus juris, that inherit Justinian's code, and that includes the common law, even if it is in the form of denial or a certain indirection and antipathy, because we English didn't or were not fond of the French, who were the most immediate instance of the corpus juris, of the civilian or Roman law tradition. Each tradition has its own forms. The Mos Hispanicus, the Spanish tradition, used fiction along with history to relay law. The Spanish tradition inherits the partides, the Roman law, and Don Quixote, Cervantes, author of Don Quixote, was trained as a lawyer, and much of Don Quixote is actually a satirical critique of Roman law and of the partides as they applied in Spain. Tilting at windmills was illegal according to the then current law. That was one of the signal points of Cervantes' novel. So fiction, Don Quixote, has a fairly important role, both in the founding and framing of the specifically Spanish tradition, but also in the confluence and interplay of literature, of a specific national literary tradition, a particular genre or form of novel, in the relay of Spanish law. In France, the Gallic tradition and the commentators were historians who said it makes no sense to treat a code published by Justinian in 635 CE as current law in France. This was law that was already antiquated at the time that it was published and now needs to be adapted to the historical and social circumstances of contemporary France. English common law is fond of mixing myth and law. So we have the concept of time immemorial, of time out of mind. We have the concept of a druidic or unwritten source of law that is peculiar to the common law and to a judge-made tradition. So if you look closely at book 50 of the digest, Antiquae Fabulae Juris, the old stories of law are what are collected at the end of the digest. Using the Morellian or Freudian method, one could say that what is peripheral is actually the best indicator, the symptom or clue of the purpose of the work. It's relaying these responsa. It is providing a juris literary tradition to which the subsequent legal institution is both dependent upon and uses as a resource or opportunity. So following on from that, if one accepts the concept and the notion of the juris literary as founding, as structural, as implicit in, as buried within, as a hidden resource and opportunity, then one can start reading legal decisions. One can start reading juristic texts as juris literary encounters. One can start to see something that is not so obvious and of which I will give illustrations in a moment. And that is that imagination lies at the source of law. Juristic and juris literary specifically, imaginary ideas motivate and are the key to the affective, atmospheric, and the directional motivation of judgment. Take in mind that any decision is a novelty. Any decision has to invent the law as it applies to a novelty, which is to say, law runs out at the moment that it hits the future present. Law runs out whenever there's a new situation, be it a new person, a new fact, a new event. If they are to be genuinely encountered, then literature will become the source of law. Bear in mind that the future is the madness of the present. And if the future is the madness of the present, then imagination, premonition, our sense of the future as we intuit and feel it now is, in American legal realist terms, the hunch. It is the corporeal sensation. It is the sensibility of what is to come that will determine the just decision or the rendering of justice, as opposed to reaching merely into the pickle jar of precedent and pulling out a corpse in the form of a precedent. If the pandemic has taught us anything, if the new world of virtuality has signified anything specific, it is that precedent is dead. It is that we need not to look to the past, which has failed us, but to the future, which is our potential and possibility. To look to the future is to become a little pataphysical. It is to look at absences. It's to look at wholes. It is to engage in what Jari and others discuss as the law that escapes between the lines of your legal texts, of the books that you impounded. Vico tells of Jura Imaginaria, and that is simply to say that Jurisliterature, internal to legal decision-making, provides a science of impossible solutions. It provides not what has been, but what will be. Not what was, but what is potential. And that involves a different sensibility and a significantly distinctive openness, an openness to the future, a sensibility, a sensorium that is prolegomena to, open for, receptive of, in corporeal and in transhuman terms, a Taylorian jurisprudence, a greater whole of which law is simply or merely a part. So I want to talk about a few examples. I want to discuss ghosts, tweets, umbrellas, and malapropisms. Those are arguably obvious examples or extreme examples, but again, in Freudian terms, in Morellian method, those extreme examples are anything but ornamental or insignificant. In other words, again, whenever a new situation is encountered, when a new person, which is to say, a different body, a non-encountered body, a new fact, a new event is genuinely experienced, where the law in the form of the judge, legislature, parliament, whomever it might be, genuinely opens corporeally, theatrically, in persona to the event and to the encounter, then imagination, feeling, sensibility is the source of law, and our guide to that is literature. So let me begin with a strange case, and maybe I can share a screen. Beanie will let me know if that's possible. Strange case called Bagent and Lee.
You may share the screen.
Did it work?
Yeah, it did.
Well, look at that, how exciting. We are joined in the commonality of our virtual technology. So let me start with the peculiar case of which I'm very fond. It's a copyright case. And of course, copyright, literary copyright, is one of the most fantastic resources for analyzing and addressing through law the role of the literary. And Bagent and Lee and Random House, the authors, Bagent and Lee, authors of a book called The Holy Grail, about the bloodlines of Christ, sued Random House, the publisher of Dan Brown's The Da Vinci Code, for copyright infringement. To come to a determination, the judge has to read and compare two novels. Question is, how is the judge going to do that? And what is the legal source and criteria of judgment? The judge engages in a 635 paragraph judgment in a very lengthy analysis of the two novels, their plot, their structures, their linguistic forms, and then says that a judgment is not a work of fiction, I hope, nor is it a piece of conjectural fact. A judge distills the facts and determines those facts which he concludes are necessary to enable him to come to a decision in the case. What does that mean? A judgment is not a fiction, I hope, nor is it conjecture. It's a distillation of facts. Well, what the judge has to determine is whether the novel is original and then so worthy of copyright protection, and then secondly, whether there has been substantial borrowing. How does the judge express? How does the Court of Appeal repeat the criteria? It's a question of forming a picture of the two works, of gaining an impression, of a feeling, of looking for fingerprints. Those are quintessentially imaginative, prospective, potential impersonations of what it is that constitutes the two works. The judge then goes on to say that there has been no borrowing, that there has been no infringement, because Holy Blood, Holy Grail, the work that is suing, lacks originality and has a framework, a skeleton of a framework that falls apart when you examine it. I don't want to get into the details, but you have a significantly literary encounter between law and two novels, and the judge's most incisive mood is to say that this is not a work of fiction, that the judgment is not literary criticism. He says it 3 times, which in Christian terms suggests that he actually means the opposite, that it is an oratorical definition. But there's one other feature to the judgment, which you may know or you may have perceived in the first page of the judgment that I have posted for you. I don't know if it's large enough to view. The judge uses the Fibonacci code, which is the code that is at the center of the Da Vinci Code novel, and he inserts in the judgment at random points italicized letters in bold font in a different typeface as a cryptogram. Humorously, not many journalists, or indeed nobody, noticed this. Lawyers paid £600 per hour. Lawyers trained to notice every syllable as known and significant to law entirely missed the fact that there was an encryption in the judgment. And the encryption, when de-encrypted, said, "Jackie Fisher, who are you, Dreadnought?" That, I would suggest, is the most fantastic indication clue, symptomatic expression of the inventive force of the judicial decision. An encryption in a judgment about codes is surely the perfect literary figure, the perfect icon of judgment, and the most extraordinary insight into the mind of the judge. Jackie Fisher, Who Are You? Dreadnought. Dreadnought was a battleship invented just prior to the Second World War that was all big guns. It was an enormous ship with enormous guns that was highly successful for a short while. It destroyed other ships by virtue of being a nautical juggernaut. There's the picture, there's the impression, there's the feeling, that's the fingerprint to the judge's motive, the judge's creative and inventive decision. In other words, the judge is moved by the fact, one, that the Da Vinci Code is the first novel that uses an academic lecture as part of a thriller, and is moved by the fact that the Da Vinci Code sold tens of millions of copies, something like 80 million copies, I think, by the time of the judgment. Bagent and Lee's work had sold about 200,000. One was a juggernaut, one was a little ship. The judge felt that it was novel envy that motivated the litigation rather than any more direct or significant legal cause of action. So the enigma, the encryption, is a figure in the judgment, a juris literary device in a very lengthy literary composition by the judge, which he says is not an exercise in literary criticism of either book. Well, perhaps the answer there is it's not a literary criticism. It's not a literary fiction, it's a legal fiction. It is a juris literary fiction that constitutes the source and constitutes the significance of the judgment. The imagination is what is necessary to thought. Sensibility, the sensorium of the image, the phantasmal that Aristotle spends so much time addressing, is precisely the trigger of thought, the installation of the past in the body of the present. And that's what the juris literary is driving us towards understanding as the most powerful source and the most significant device in interpreting judgment in a future-directed perspective, understanding the corporeography of decision, the Taylorian basis, and the futuriety that fiction alone, imagination alone can offer, because we don't know what's coming next. Another example, an amazing American case. Shall I give you a picture again? Maybe I will. I'm in a generous mood. Oh, that's the link to the conference. So the case in question is a remarkable one from New Jersey in the United States. The defendant owned a house which she used commercially and advertised commercially as being haunted. It had a poltergeist, and she advertised and for money led tours to see the poltergeist. When she sold the house, she made no mention of the fact that it was haunted or of the existence of a poltergeist, presumably because if you are like myself, a humanist, poltergeists are simply a metaphor for various other forms of projection, various other atmospheres, affects, and intuitions. That said, when the purchaser discovered that the house had been advertised as haunted, they endeavored to rescind the contract of sale for misrepresentation. Well, amusingly, under US law, for a contract to be rescinded for misrepresentation, the misrepresentation has to be material. So the question is a ghost material? And there's a very strong dissenting judgment which says that if the doctrine of caveat emptor is to be overturned in the law of New Jersey, then it must be for reasons more substantial than ghosts and poltergeists. The majority, however, took the position that the misrepresentation was material, the house was legally haunted, and rescission was available for material misrepresentation. How does the judge come to that decision? Well, one argument is that due diligence on the part of the buyer would not discern, see, or otherwise discover the existence of a ghost. But more importantly, law has run out. This is a novelty. This, in other words, is an exemplary instance. This is a question of a ghost in a house. What does the judge do? The judge turns to Shakespeare, turns to Hamlet, cites the ghost in Hamlet. Pity me not, but lend thy serious hearing to what I shall unfold. And from the discourse of the ghost in Hamlet provides a spectral conclusion. In other words, what your serious hearing will listen to is the unfolding of the importance of the spectral in the mens legis of the private law of contractual decision. The ghost, like the idea, like Hobbes's angelological theoretical expressions, is crucial to the decision of the buyer and therefore to the determination of law. The ghost is there, not because there is a ghost, and this is, I think, the brilliance of the decision, but the house is haunted. It's not a ghost that is apparent, but a structure, an architecture, a building that is haunted. And if it is haunted, because that is what for many years the owner has projected, claimed, and earned their living by leading tours around, then that is a significant and material feature of the house. But from a Juris literary perspective, I hope you can appreciate the recourse to the discourse of ghosts, the recourse to the imaginative potentia of literary judgment is, and at some level always is, that tingle or shiver, atmosphere or affect that instigates judgment and that propels the expression of decision. So what I'm trying to suggest is that one can disinter, one can research and find, one can look and discover Juris literary foundations, Juris literary bases, affective commonalities that language carries with it and that literature acts as host and as archive too. These are the potentials of judgment. These are the moments where we see in the figures of decision, the images, the imaginary that has shifted the body that decides to express in the manner in which it expresses. If I had more time, I would be interested in expanding that particular notion of wild judgment drawn from the language of decision to the amazing case of Suresh and Siddique in India, the one that lasted about 50 years, in which the question was whether or not the Muslim temple was built on the birthplace of Lord Ram. And the question had to be answered archaeologically and stratigraphically. Were there signs in the earth of the presence of worship of the divinity Ram from the 13th century? And the answer was that the earth spoke. So again, a wonderful Taylorian manner of addressing, not particularly consciously, and in I think 4,000 pages of decision by the end of the final decision, not a single image, although it was images, patterns in the earth discovered archaeologically that were supposed to determine the case. But again, you can see the jurisliterary point in Siddique and Suresh, and it references, there's another case I can't pronounce, so I won't be rude and attempt, but a case in which an empty altar is worshipped as a representation of Shiva, and the air there is the image of the divinity that allows the deity a juristic personality. But let me move on to more mundane common law, with which I'm more familiar. Time and again, if the question is one of novelty, if the law is having a genuine encounter as opposed to an unconscious and repeated precedential sleepwalk through judgment, then one will find again this recourse to the imaginary, to potentia, to the pataphysics, as I like to call it, of imaginary solutions. The Bible is a very common source, that greatest of works of fiction. In R and Cambridge, Rex v. Cambridge from 1823, University of Cambridge was sued by a fellow of one of the colleges who was stripped of all their titles and fellowships for calling the vice chancellor of the university Stulte Egget foolish. The university had a congregational court, the vice chancellor's court, and the vice chancellor's court held a hearing in which they confirmed the expulsion of Dr. Bentley from the university, from his fellowships, stripped of all, except for his rectorial role, apart from his parochial role, in other words, as a priest. He sued, and the issue was that although he had been told of the charge, he had never been summoned to the congregational or vice chancellor's court. And the judge, dealing with this problem of a court at the university that had existed time out of mind from time immemorial, that had always had coeval with its existence the power to strip fellows of their fellowships and their titles, was acting within its powers, and specifically whether it had infracted a rule of literary justice, of natural law drawn from Medea, that is, you cannot charge and you cannot convict without hearing the other side. Audite ad alteram partem comes into English law pretty much at that point. Where does it come from? The judge says a very learned man had informed me that even God in the Garden of Eden, so a reference to the book of Genesis, asked Adam for his response to the charges of having eaten of the fruit of the tree of knowledge. And Adam replied in good masculine fashion, well, Eve told me to eat it. And Eve responded that the snake had asked her to eat it. And so God in the end punishes the snake, who isn't heard, has to walk on its belly, but also punishes Eve and Adam by expulsion from the Garden of Eden. But the point that the judge is drawing, and the citation to Genesis, is precisely that Juris literary foundational encounter, that feeling in the body of the judge that tells him how to paint, how to render, which is to plaster or paint, justice in that context. What does the body say in answer to that question? In a tweet case of which I'm fond, Chambers and DPP, and maybe I will, in fact, put these up before I finish. So in Chambers and DPP, the question was that of a tweet by a tweep, that is a Twitter handle, who is enamored of another tweep, Crazy Colors, who lives in Belfast. He goes to Doncaster Airport. He realizes the airport is closed by virtue of snow, and he tweets, "You've got a week and a bit to get your shit together, otherwise I'm blowing the airport sky high." That's on social media. He has about a lame 630 followers, but eventually the South Yorkshire police get hold of it, and he's charged under the 1935 Post Office Amendment Act for misuse of the telephone to communicate indecent, obscene, or menacing messages. The 1935 Act is incorporated into the 2003 Communications Act, and the first 5 pages of the judgment are literally a reproduction of the 2003 Communications Act as a screen or mask or a device to hide the actual basis of decision. As deflection, in other words. The tweep, Chambers, is charged in Doncaster Magistrates Court and is given a significant fine and a suspended prison sentence. He appeals, and the appeal is affirmed. His menacing message is clearly menacing, and this joke, as I would call it, this jocastic tweet, is viewed as grounds for an extension, an augmentation of the fine, and an increase in the severity of the punishment. And it then goes to the High Court, and it goes before Judge, who judges in favor of the tweet, primarily by virtue of a huge popular and social media and newspaper outcry against treating a clear, informal Twitter message as being serious and menacing. Nobody who knew social media would take it as such. And how does the judge deal with it? He hides the decision behind extensive, prolix legal verbiage between the prose and apparent objectivity of law to end up with King Lear and the weight of this sad time we must obey, speak what we feel, not what we ought to say. There is the source of the decision. Speak not what we ought to say, speak what we feel. judges in favor of overturning because grammatically the tweet wasn't sufficiently syntactically correct to signify seriousness, and its audience was hardly one that would act upon such a message. But why? Because in King Lear, and had I more time, I'd go into the context of that particular statement, stretch us not out upon the rack of this cruel world more long, but it again is the trigger, the motion, the motive, and the direction of decision. So I see that time, the sands in the hourglass run thin. I want to end by just talking about judge again, and a case concerning textiles. And I had a long piece on textiles, in a case where the judge uses textile metaphors, the language of judgment, in a case where defective textile had been sold by a manufacturer to a purchaser, as one instance in a year-long 38 transaction relationship or network contract. And the judge says that the claim by the plaintiff in the parlance of the industry is that the other side is spinning a yarn, and the counter by the defendant is that the plaintiff is warping the facts. The particular transactional weave is depicted as an invoice and order acknowledgement that contained a twist, additional terms tucked into the back of the document. The plaintiff doesn't request any alterations, but just claims that the arbitration clause has not been woven into the contract. And it goes on and on like that. And that form of metaphoricity or figuration is not uncommon in judicial decisions where the issue is a slightly looser or more novel one. It comes to the fore. And the question is, what do the woolen metaphors mean? What's the significance of the metaphoricity? Does it matter? Or is it doctrinally merely an ornament? And the answer is, think again. Think again. It's a juris literary incident. It's the interweaving of woolen metaphors in the strictest of senses, being metaphorical and entirely opposite to the decision, just as the spectre, the ghost, emerges in the judgment in the haunted house case. Wool gains expression, the matter and sensibility of the doctrinal substance emerges in the language, expression, and figuration of the decision itself. The allegoresis is the best possible homonymy or complementarity between what is being judged and the expression of judgment, the source of judgment, the foundation and motive of decision, the imagination in the body that actually decides. So that is textile and ABMH. And then in Baird and Marks and Spencer's, we're engaged again in a 30-year relationship between Marks and Spencer's and a textile manufacturer who basically works for Marks and Spencer's, and Marks and Spencer's has members on the board and has made significant financial contributions to the defendant company, which every seasonal contract, of which there are 60, they alter their manufacturing, they change their product and lines to satisfy Marks and Spencer's particular current fashion interests and designs. A Court of Appeal, Lord Mance, in saying that there's no contract, says objectively the sensible judgment is that the parties had a very good long-term working commercial relationship that they wished to keep flexible and did not intend to be contractually binding. Judge in his judgment has the following to say, because we're dealing again with a novelty. We're dealing with something that the First Court did discuss in terms of an umbrella decision. in terms of, does 30 years create an umbrella contract? Does 30 years of close commercial relationship generate an umbrella contract, a governing carapace of protection through legal recognition of course of performance over an extended network and period of time as giving rise to legal rights? Is there a structure there? Can we imagine something? Can we imagine a parapluie or an umbrella? Judge says, however settled the law may appear to be, one of its strengths is that the possibility of development or change remains. In my view, even for the purposes of summary judgment, we must apply the law as it is, not as it may possibly one day become. My emphasis, he says, not as it may possibly one day become. But what is common law? It is jus non scriptum. It's an unwritten law. It is an image. It is custom and use over time. Here, they're making clothes for Marks and Spencer's for 30 years. Is the law to give no recognition? Can that relationship be ended with the cut of a knife, the fall of a guillotine in a moment, without any compensation for the aspirations and expectations of the party that has been faithfully serving the other party for those 30 years, for those 60 seasonal contracts? Well, it's a question of clothes. So we need to go to Sartori Satis, we need to go to Thomas Carlyle, we need to go to the philosophy of clothes. And I think that Carlyle would say this is the tarantula dance. This court has no ear for literature. An umbrella is an article of proper dress, furled or unfurled. That apotropaic sign is a protective device against the evil of arbitrariness. And if the common law cannot recognize, if in Mance's judgment it is so insensible that it cannot perceive, apperceive, attend, or hear the sensibility of an unwritten relationship, of an unwritten practice, of an image, of institution, and of bonding, then the failure to recognize a juris vinculum, a legal tie, a commercial marriage, is something that is sadly lacking. The law as it may be is precisely what the judge in Juris literary terms is endeavoring to pinpoint and to express. That is justice, whereas judge judges in a retrospective, passive, and dead fashion. The pickle jar of precedent kills another potential. And with that, I will end. Thank you very much.
Thank you, Professor Goodrich, for introducing us to the varied nuances of Juris literature. You really compelled us to look beyond the limited vision of procedures, interpretations, and representation through an analysis of Juris literary tradition and contemporary developments. What drew my attention is the darkly humorous side of law, bordering the ludicrous, sort of Kafkaesque absurdity, which makes it all the more complex, intriguing, and even menacing. Now the session is open for questions, comments, and observations. You may post the questions to me in a private chat or raise your hands. Use the raise hand facility for the questions. Students, any questions, comments, observations?
Well, I work in a US law school and we call on people. In other words, dialogue is engendered by intimating a question. So there are no faces. Monali Chatterjee, did you have a reaction? Muted.
Manali, do you have a question?
Okay, you're not used to the Socratic method.
My question, am I audible?
Yes, you are.
My question is regarding Da Vinci Code. Since you mentioned about this in a very different light, I need to know, in case, since there are a lot of questions within Da Vinci Code wherein religion is actually at the witness box and there are characters who are questioning its veracity in various ways. And in many ways, it is for the reader to decide whether they want to believe it or not. Do you think that Dan Brown would have wanted to raise it in a way that people would be able to sit in judgment in the court of law and pass a sentence about religion? Is that possible or is it just a random intent of the author that has just come up as an interpretation?
Yeah, that's so interesting. So a lot of the judgment and the judge who was reprimanded by the Court of Appeal for including the encryption in the judgment because they viewed it as a distraction, whereas I would view it and wrote a lengthy article about how it was the sort of symptomatic key to the judgment, and also in a long tradition of what are called enigmata juris, enigmas of law, which are terms of a polysemous kind. In Renaissance law, an ambiguity is legally recognized because an ambiguity has a resolution. You can choose between one of two meanings. An enigma is a term that has more than two meanings, and therefore being polysemous cannot be legally resolved unless one can discover the forgotten reference to which it refers, or its denotation historically or in literary terms. But much of the decision was concerned with Dan Brown's research for the book, so that there is a certain light. His wife is the primary researcher, and it's very clear that she had used Holy Blood, Holy Grail as one of the primary sources for the thesis of the book, which was that Mary Magdalene had had a child by Jesus, and so there's another bloodline, and that's been the great secret of the church. As to whether the novel itself seeks a judgment of religion, I think it's interesting. The English, England in general is less kind of religiously insane than the United States, so that there's a slightly different status to religion. I think in the background, there is very definitely a humanistic or rationalist view of religion. And that's the reason I use the example of Rex and Cambridge University, because they use the Bible as a literary text. In other words, there's a suspension, I think. There's a virtuality to the status of the Bible. And in Smith's very lengthy judgment, the veracity or the falsity of the biblical text is something that is held forever in suspension. So the judgment, and of course there is always a judgment, the judgment is to defer judgment on that specific point, that virtuality. But in deferring judgment, one is also expressing a dubiety, a poria, or a doubt about the faith which is to say, doubt as to faith or belief in what is not. So I'm not sure if that directly addresses what you were asking, but it's my best attempt at 6:58 in the morning here.
Yeah, there's a question from Dr. Rakesh Nambia. He wants to ask, what future do you think law and literature are taking shape into?
I'm eccentric, maverick, pataphysical, and at times flamboyant. So I'll give you the following answer. Law and literature is dead. The copulative endeavors of law, for a brief moment, included law and literature. But then law was unfaithful. It copulated with other disciplines. It had mistresses. The marriage ended rapidly. And a professor called Julie Stone-Peters, who I'm fond of, wrote about the death of law and literature. It was this theatrical debacle in which literature professors felt that they could gain status and gravamen for a discarded discipline by studying law. And lawyers believed that they could have a day off or time out, that they could gain some pleasure by looking at literature as a source and resource for law. But that copulative endeavor is, I believe, a dead end. Jurisliterature, well, that copulative endeavor is belles lettres. It's a belle lettriste view of law. Whereas what I want to argue is that law is a profound and, of course, a very humorous genre of fiction, of potentia. And that every time the law moves, it moves by virtue of imaginative, creative, inventive, jurisliterary instigation and propulsion. So that you don't have to go outside of law. It might be fun to do so. You look at the movies, you look at the paintings, you look at the novels where there are lawyers as figures, and yes, that tells you something, but it doesn't tell you very much. It's a context. It cons the text, as it were. It is not intrinsic to the juristic enterprise. What is intrinsic to the legal enterprise is the jurisliterary endeavor. In other words, it is what lawyers write, the imagination of lawyers in terms of how we ought to live, in terms of social structure, institutional practice, mores, potentia, and future. Pandemic, I think, again, feeling repetitious this morning, does teach us in a sense that precedent is dead, that it doesn't provide very valuable solutions, that its only meaning is forward-facing, and it is in facing forwards, in premonition, in prognostication, in intuition, affective judgment, that we actually encounter, that we embrace, that law opens to the event, and therefore renders a justice that is pertinent to the event and to the matter that comes before it.
We have a question from Nainika Singhal, who was the student coordinator of this program. She asks, over the course of history, various legal and literary terms changed their meanings from what they had intended to their impact. How would you weigh it on the usage of such words in more egalitarian context when the original intent goes against equity?
Sorry, I missed the middle of that. How can one introduce a more egalitarian
context when the original intent goes against equity?
So I'm really fond of Earth jurisprudence and the Wild Judgments Project. So there's a fabulous article in which, and I don't know if you know the case, but there's a very famous English tort law case that introduced the concept of the neighbor principle. And it was a case that involved a woman purchasing an opaque bottle of ginger beer, drinking it and finding at the bottom the decomposed remains of a snail, and bringing an action in tort. And the court had to determine that despite the absence of any privity of contract between the drinker of the snail-imbued ginger beer and the seller, there should be a cause of action, that it was foreseeable on the part of the manufacturer that if there was a snail in a bottle of ginger beer, then sold by a blameless retailer, because the bottle is opaque, the manufacturer should be liable. And the Earth jurisprudence take on the case is that what we've missed in looking at the Good Samaritan and the neighbor principle, again, biblical sources for the decision, is that we haven't taken account of the rights of the snail. In other words, view it from the perspective of the snail. View the woolen case from the perspective of the wool. Earth jurisprudence, in other words, is trying to enlarge to a non-human or transhuman context and take account of the corporeography and the embedding of the decision in a Taylorian and natural ground. And that sense of grounding is what lies at the basis of the new materialism. And I think it is in significant part precisely egalitarian, but the egalitarianism that we're talking about, the egalitarianism that is crucial, is between species, planetary as well as merely human. So if we then move to language, law is obviously an elite and hierarchical sociolinguistic register. And so the juris literary is precisely trying to expose, address, appreciate, and criticize the judicial mode of determination through the judicial expression of judgment, which is, of course, the language of decision, and to look at the creative and inventive moments. How does the judge author? How does the judge create and write? And when we have a better sense of that inaugural or triggering figuration, then its elitist sources, then its idiosyncratic bases, then its class and racial divisions and expressions, then the history that comes with it, that is embedded in the language, can be exposed. And that's kind of the basis actually of my PhD thesis, Legal Discourse, which was an analysis from a leftist or Marxist perspective of the sociolinguistic import. In other words, the hierarchical character of law that was carried in the language itself and could be deconstructed from the rhetorical figuration of judgment. And then you have a more comprehensive context, and you have a less narcissistically humanist view of the motive and of the practices of the legal institution.
A question from Priyam Singh. As director of a program of law and humanities, what are your considerations in structuring a syllabus on this interface of law and humanities?
Okay, I fear this must be my last answer, as I have to go and teach in a moment. That's a fantastic question. And here is my answer. Can you see it? I tried to devise effectively a syllabus there, which develops through the Juris literary tradition. So bear in mind that the Juris literary tradition is a tradition of enchiridia, of prolegomena, of introductions, of preparatives, of legal enticements into law. So you start with the works that lawyers have used up to the present day to introduce the polity to the Republic of Lawyers. And there are wonderful utopian and other works looking at that. Res Publica Juris Consultorum by Gennaro is the example I use. But the Republic of Lawyers, I try to argue, from Plato onwards, is the Republic of Letters. The two are one and the same. And if you read Plato's Laws closely, what he says is not that law and poetry should be distinguished, but that law is the best poetry, the poetry that lasts. So that's the sort of inaugural thesis. Then I moved to look at the discipline of law, in other words, the emergence of the Mos Britannicus Juris Dicendi. In other words, the national character, the introduction of a common law of England in opposition to Roman law for political reasons. It doesn't want the tincture of Normanism. So it engages in a mythology of an unwritten law, which is a law of images. It refers to time out of mind, time immemorial, a law so old that it goes back to God itself. It is the oldest of the laws, older than that of the Venetians and of the Spartans, etc., etc. So there's this wonderful mythical dimension, which is, of course, a figurative and literary dimension. And then I moved to allegory, allegoresis, and the metaphoricity that one finds in judgments. Then I move to the contemporary, or the more contemporary, the immediate future, which is the subject of the book I'm just finishing at the moment, Vision and Decision, which looks at images that judges introduce into judgments. Internet relay, digital archiving, judgments on the net. Judges now increasingly incorporate photographs, images, film clips, and other visual materials into judgment. There you have an incredible resource into the unconscious of law. So I spend a lot of time viewing, because I think it's not a question of visual literacy, it's a question of visual apprehension. The law that judges and the precedent that decides utilizing an image is addressing and engaging in a whole other layer and level of determination and of precedential relay that hasn't been thought through and that hasn't been critically apprehended. And in doing so, the judges lay themselves open or provide an incredible opportunity for what I term Juris literary invention, which is to say the science of imaginary solutions. That's the future of law. And I think we have to start thinking, viewing law in a different manner, because the most recent figuration is actually, imaginal representations, visual depictions. So that's my brief answer. Happy to send you a copy of the book, of which I happen to have a large number of copies if you want one. Okay, and
Thank
with
you.
that, Bini, a delight to meet you. Monali, thank you for your question, and an enormous pressure. And Bini, we'll stay in touch, and I'll try and devise a written version of my monologue for you at some point.
Thank you once again, Professor Goodrich, for your keynote address, which was literally and figuratively central to our conference, because it happened in the middle of the conference. So tomorrow we will start with Professor Upendra Bakshi's address at 10 a.m. Thank you very much.
10 a.m. is about midnight my time. So.
Yeah. This is for the other participants. So.
But a great pleasure. Okay, thank you so much. Great to meet you, and we will stay in touch.